Clive.
Hello, Colin.
Welcome to another podcast.
There we are. Another day, another podcast.
Absolutely.
What's on the menu today?
Oh, it's right up your street, Clive. It's alcohol and drugs.
Oof, steady.
Hey?
In that order.
It's only missing sex and rock and roll.
Sex, drugs, and rock and roll. That should have been the name of the podcast, shouldn't it, Colin? But it is the Unholy Trinity: drinks, drugs, and the driver.
Absolutely. Drink, drugs, and the driver. As a society, I think we've always taken the view, haven't we? You can have a drink. Who doesn't like a drink, Clive? Hey, you could even take illicit drugs, I suppose, if that's what you want to do. I'm not condoning it, you understand. But society at large tends to say, if you're going to indulge, stay away from your motor car.
Yeah, seems reasonable. Although in Scotland, Colin, the law's rather different, isn't it? You're not allowed any alcohol in your system north of the border.
Are you not? No, crikey, I thought you were going to say it was compulsory.
Steady, Colin. My Scottish ancestors might have something to say to you.
Indeed. I have not.
No.
So let's just then, as a couple of lawyers, which we are, let's just examine what's all going on in relation to alcohol and drugs and driving. And we go back, don't we, to the Road Traffic Acts of 1988. Gosh, I'm old enough to remember the Road Traffic Acts of 1972, but we'll not go there.
Let's not dwell on that, Colin.
Back in 1988, we were given, weren't we, the Road Traffic Act of 1988 and the Road Traffic Offenders Act of 1988.
Why did we have two, Colin?
Oh, basically because the Road Traffic Act of 88, that seems to deal with the creation of the actual offences, whereas the Offenders Act concerns itself more with disqualifications, penalty points.
What happens when you become an offender?
Yeah, the ramifications.
There we go.
Obviously, you'll have a link to the Road Traffic Act of 1988 and a link to the Road Traffic Offenders Act of 1988. And I would particularly commend to you that you read sections 4 through to 7A. Sections 4 through to 7A of the Road Traffic Act of 1988, because that gives you all of the summary alcohol offences that we're going to be dealing with during this particular podcast.
Good. I'll just say, Colin, for those of us joining for the first time, others might not have listened to any of the other podcasts. This might be their first one, in which case you're very welcome. But for each podcast that we produce, there will be show notes. So if you're walking the dog, driving your car, or doing something else that requires your hands, like drinking a cup of coffee, and you can't scribble down all these references, don't worry, we've done it for you, and they will be available in the show notes, which you can download and click on all the links to read all this stuff and save you the job of reaching around the internet and find it, won't we, Colin?
Excellent. Because we've done that for you, I hope.
Yes, we have.
If we consider for a moment Section 4 of the Road Traffic Act 1988, been with us for a long time now, since 1988, it's always been an offence under Section 4, if you think about it, for your driving to be impaired, for you to be unfit, for your driving to be impaired through drink or drugs. Common sense, I suppose, if you think about it. Society needs protecting from those people who want to drink to excess and those people who, whatever drug they've taken, it could be any drug at all, it renders you unfit, whereby you're impaired to drive. Clive, I'm sure you'd agree with me that if you've taken drugs or alcohol and you're unfit or in some way impaired, you'd be concerned, wouldn't you? As a member of the general public, you'd be concerned.
Does this apply to prescription drugs as well, Colin? Because often when you read them on the box, it says you should not operate heavy machinery or drive a motor vehicle after taking these drugs.
Well, let me put it this way. Section 4 is drafted very widely. Section 4 is drafted very widely. The prosecution have to establish that you are unfit, that you are in some way impaired through alcohol or drugs. You couldn't draft it any wider.
Sometimes it might even be both, Colin.
Well, quite, yes. And there we were. There it was left to rest. And everybody was happy, I think, or reasonably so. And then, of course, the powers that be decided that it all needed a rethink. And the rethink, of course, came about in March of 2015, when we were given Section 5A of the Road Traffic Act of 1988. And we were given a statutory instrument with a schedule of permissible levels of drugs that you could have in your system. And if you exceeded the particular level, it mattered not that there was nothing wrong with your driving. You were caught by the offence of effectively driving, attempting to drive, or being in charge with a proportion in your blood in relation to those specified drugs that were specified in the schedule. Now, I don't know about you, Clive, but my first thought back in March 2015, when I read all of this, was, do we need it? Hey, what does it add to what we've already had since 1988? And perhaps more to the point, should we be criminalising those people who are not in any way impaired or unfit to drive? Over to you.
Yes, I see that point, but equally, as you say, there is I suppose you can take either purposive or a literal approach, can't you? You can, as we do with drink driving, there is a prescribed limit, and there is effectively, isn't there, a presumption in law that if you are over the prescribed limit, then you should not be driving because you will be impaired in some way. Now, there will be some people who will be impaired long before they get to the drink drive limit. There'll be others who will be over the drink drive limit and may not be impaired. Thinking, do you remember the snooker player, Colin, Bill Werbenek? He was a Canadian snooker player, and apparently used to have 15, 20 pints before he could get his eye in on the snooker table, didn't he?
Just to steady the pool cue, snooker cue.
Mr. Werbenek might have said, I've had 10 pints and I was absolutely fine. But of course, Parliament has said, no, there's the limit. And if you're over that, then you can't drive. But equally, on the other hand, as you say, there are these limits where people will say, well, I've got the drug in my system, but I'm not impaired in any way. So why should you be criminalising me?
Indeed.
Particularly, as you know, Colin, when these drugs can hang around in your system for quite some time, can't they? It's not like with alcohol, most people might have a drink one day, sleep off, have a hangover the next, and be fit to drive maybe later that day in the afternoon or the following day. It's not much of a gap between the consumption of the alcohol and the driving of the car, is it, for you to be fit to drive again?
That's right. So going back to the legislation, of course, we've got Section 4, unfit, impaired through drink or drugs, 1988, nothing wrong with that. Section 5, effectively driving, attempting to drive or being in charge with an alcohol concentration above the permissible level. And we've had that since 1988, and we all know what that's all about. And then we get this new creature, don't we, tacked on in March 2015, Section 5A of driving, attempting to drive or being in charge with drugs in your system above the permissible levels, those levels being set out for us on a statutory instrument. And we know, don't we, the two most common ones, I would have thought, are cannabis, where you're allowed to have no more than 2 micrograms per litre of blood, and the old cocaine, where you're permitted to have no more than 10 micrograms per litre of blood. And I'm told by people who know more about these things than I do that these are minute quantities. These are minute quantities within your system. We are almost at zero tolerance as regards illicit drugs.
Well, also, Colin, I think I'm right in saying that the roadside tests that the police conduct only test for those 2 drugs as well. So the only way you're going to test the others if you get taken to the police station and blood's taken, isn't it?
Yeah, I'm not sure if that's now as true as it once was.
Is it?
There we are. I think some of them might be a bit more sophisticated now, but I know what you mean. These are the kits, aren't they, that the officers carry around in their
saliva tests, aren't they? Yeah.
It is, isn't it? Yes, it's a saliva test. It'll show up, won't it? Cocaine and cannabis. I don't know. It might be a bit more sophisticated. It might show up something else now. But there you are. So we've got 5A. Who's at the sharp end of all of this? I tell you who's at the sharp end of all of this. The poor solicitor in court. You might be the duty solicitor having to say to the client, look, you've given a reading, in excess of 2 if it's cannabis, or you've given a reading in excess of 10 if it's cocaine. That puts you over the limit. You've nowhere to go. You're a guilty plea. And you might be a guilty plea because you smoked a joint of cannabis at a party. I don't know, Clive. How long ago?
I don't know. I suppose it depends how much you smoked at the time, doesn't it, in terms of whatever the half-life of it is, as it were, in this system. But we know, don't we, from experience, that cannabis can hang around in your system for 21, 28 days, don't we? Certainly, I've had clients with mandatory drugs tests in prisons over the years where, they would have smoked it weeks ago. And of course, as we know, that's why sometimes people go in smoking cannabis and come out taking Class A drugs, because they can take Class A drugs, drink a load of water, wash it out of their system, and still pass their mandatory drugs test. So, yeah, cannabis can certainly hang around in the system for a long time, can't it?
There may be some people out there shouting, yes, but as a society, we've taken a decision that if you're going to smoke joints at parties, if you're going to go to good parties and snort cocaine in the bathroom, that's fine.
Is that your idea of a good party, is it, Colin?
But don't go near your car.
Yeah, quite.
Well, I make a serious point that here's me now as a poor solicitor having to tell the client, look, my friend, you're a guilty plea. Okay, so what does that mean? Well, it means a hefty fine for starters, and you're going to be disqualified for a minimum 12 months. What? Yeah. You're going to be disqualified for a minimum of 12 months. But there was nothing wrong with my driving. But we made a decision, didn't we, as a society back in March 2015, there need be nothing wrong with your driving. In fact, I've saved the really bad news until last. And the client says, what, there's more bad news? I say, yes, I've had a word with the legal advisor. And on your record, it would appear that you have had 2 disqualifications of 56 days or more in the previous 3 years. And he might say, yeah, I agree with that. About a year ago, I was disqualified for 2 months for using a vehicle without insurance. And 18 months ago, I was banned for 2 months for doing like 110 on the motorway. Why is that bad news? I said, well, it's bad news because it means that being a person having had 2 disqualifications of 8 weeks or more in the 3 years prior to the commission date of this offence of drug driving, your minimum ban today for a ban, minimum period, 2 years. So those things that you did 12 months and 18 months ago, apropos speeding and no insurance, albeit you've already served your bans for those, they're coming back to haunt you again.
And there's no early release from this, is there, Colin? One of our other podcasts is Inside Out, How Long Will I Serve? But there's no early release from a driving ban, is there?
Well, there is after a fashion, isn't there, if it's for alcohol, because you can go on one of those schemes, can't you, whereby you can get your ban reduced by 25%. And the client says, oh, I like the sound of this one, Mr. Beaumont, tell me more. To which my response is, well, it won't apply to you, Sunshine, because you're drug driving. And there's no scheme for drug driving.
Is there any good news, Colin?
Yeah. Chances are you won't go down today. Yeah, it's going to hurt you in your pocket and you're going to be banned for some considerable time. And looking at the guidelines, of course, it's a minimum obligatory disqualification absent special reasons of 12 months. But the guidelines do suggest, do they not, heightened periods of disqualification dependent upon your reading.
Yeah. Initially, when this came into force, Colin, there were no guidelines around either, were there? And I mean, the magistrates and district judges were rudderless, weren't they, in terms of what sentence to pass?
They were, but the Sentencing Council did publish a document, Guidance, November 2016. In fact, it's a link. One of the links is to the guidance published by the Sentencing Council. Of course, this was all changed, wasn't it, when we had 12 new road traffic guidelines published by the Sentencing Council, proper guidelines with effect from, I believe, something like the 1st of July 2023. And again, you've got a link to those 12 guidelines.
Yeah. I mean, I don't want to be unkind to the Sentencing Council. They've had enough to deal with lately, but that they had to rush these out, really, didn't they? Because the magistrates and district judges were saying, what do we do with these people? Because going back to your original point, people were pleading guilty or being convicted of these offences where there was no impairment. So how do I factor that into my sentencing exercise in terms of culpability and harm?
Most people seem to be ending up with a financial penalty. Obviously, it's a level 5 fine, unlimited. So it's a fine dependent upon your ability to pay that particular fine. And absent special reasons, a ban. And most of the time, the bans were kept at 12 months for the simple reason you've just made, Clive, that there were no other guidelines as to circumstance in which the ban should be lengthened.
Yeah, quite.
But we did move, didn't we, in March 2015 to a system whereby, as far as drugs are concerned, it is an offence of strict or absolute liability. I can see very little wriggle room, legal term there, wriggle room, for drug drivers.
Yeah, quite.
Special reasons. Ooh, I do like special reasons, as in, I went to a party, my drinks were laced. I thought I was drinking alcohol. Not my fault, some joker put gin or vodka into my orange juice. Think, I put you on the spot here, Clive, think. Any special reasons come immediately to mind for drug drivers?
Well, someone might put drugs in your drink as well, Colin.
Drugs in your drink.
Someone might have made some cannabis brownies, of which I was unaware.
Oh, cannabis. Oh, you seem to know more about this than you should, Clive.
It's almost as if I thought about this or might have had some Clive's list of defences and special reasons.
Absolutely, yeah. Cannabis laden.
You did ask, Colin. You did ask.
Yeah, but I didn't give you advance warning, did I? So I'm troubled by the swiftness of your response.
Possibly, Colin.
It's there, though, isn't it? I wonder how many clients want to avail themselves of that. Yeah. Hey, of course, you could try the old, I was in a confined space with my mates, and my mates were smoking cannabis really heavily, and I've therefore, as it were, taking it in by way of, I don't know, assimilating it. Well, I'm afraid the Sentencing Council saw you coming and headed you off at the pass on that particular one, because their guidance does say that the levels have been set, whereby you can't get to that level of cannabis simply by taking in other people's cannabis fumes.
Yeah, so that defence is a non-starter. This is an issue sometimes for prison officers and, healthcare professionals who work in prisons, Colin. They come out of prison and say, I have to have a nap for an hour before I can drive home because I can feel myself being influenced by all of this. It's no laughing matter.
No, so again, back at the sharp end in the magistrate's court, there he or she is on the receiving end of a ban, minimum 12 months, could possibly be a minimum of 2 years, a fine plus a ban. And of course, it's even worse if you've got a conviction within the 10-year period for one of those offences listed within Section 34, subsection 3 of the Road Traffic Offenders Act 1988. Because if you've got a conviction for one of those in 10 years, you're banned today. Starter for you, Clive? How long?
3 years.
Yeah, 3 years. Yeah, 3 years. And of course, it's mix and match. Last time, 9 years ago, it was alcohol. Yeah. Today, it's cocaine. But it's still a 3-year ban. I don't know. But I would have thought for a lot of people out there, a 3-year disqualification from driving is really, really, really troublesome and disastrous if you drive for a living.
Yeah, well, end of that, isn't it? But no, absolutely.
So there you are. This is the bad news we have to convey. And I always say when I'm training in this particular area, watch out for the old failing to provide at the police station, because you might be asked to provide a specimen and fail to do so, apropos driving or attempting to drive. And failure to provide in those circumstances is an obligatory disqualification and is therefore mentioned as a specific offence in Section 34, subsection 3. But why else might you be asked to provide? other than driving or attempting to drive? And the answer, of course, is in charge. Watch out for people who fail to provide in charge, because that doesn't carry an obligatory ban. And therefore, that won't put you in section 34, subsection 3, because failing to provide in charge, that carries 10 points.
There are some obscure workers who have to be subjected to drink drive provisions, so on there. So people who work on the railways and things as well, they can be tested and taken off to the police station and things as well.
Pilots can be tested, can't they?
Yeah, quite.
Yeah.
I hope they are regularly.
I'm not saying that you won't be disqualified necessarily for being in charge or failing to provide in charge, but of course, if you are disqualified, it's a discretionary ban instead of points. And of course, because it's a discretionary ban, it's whatever period the magistrates or the district judge wants to impose. Gosh, if I'm the lawyer representing a client on the receiving end of a discretionary ban, I'm trying to plant a seed, a discretionary ban of fewer than 56 days, please.
Yeah, quite.
Yeah, we try and keep disqualifications of 56 days or more off the client's record. And it is fewer, isn't it? Fewer than 50, not less than.
Not less.
It's fewer than 56 days. All those signs in the supermarket, they used to make me angry. 5 items or less. 5 items. It's not 5 items or less. It's 5 items or fewer.
Or fewer.
Dear, oh dear. Less mashed potato, fewer peas. Hey, dear, oh dear. Did these people ever go to school? I asked myself.
This podcast is recorded on behalf of Legal Eagle Training. You can find us at legal-eagle-training.com.
Legal Eagle Training has nearly 100 one-hour recordings already on the website, and most of which come with complete with notes. We've been doing these now since June 2020 on topics as diverse as
the Magistrates Court, including the Youth Court,
life at the police station,
road traffic,
advocacy, Magistrates Court advocacy, Crown Court advocacy,
criminal law updates, including case law and the latest legislation,
and the subject we both know most dear to your hearts, the billing of criminal legal aid.
The website is constantly being updated with new courses on the latest topics. We add 2 further presentations on the website per month. Each presentation lasts an hour and comes with a full set of notes. Do visit the website, as there's going to be something there that appeals to you as someone involved in criminal law.
Right, back to the episode. Meanwhile, back at alcohol and drugs. So we've established section 4, which I thought was very sensible.
Colin, have you had some caffeine? Is that why you're getting excited?
No, hot chocolate. Hot chocolate is my drug of choice.
Well, it had to be omitted chocolate from the Psychoactive Substances Act. Do you remember, Colin? Was it chocolate, nutmeg, tobacco, various other things? Yeah. Oof. Crikey, I've overdosed on nutmeg too many times to remember, Colin.
No, absolutely. Oh, what? God, dear. I tell you this, I don't remember the 70s because of nutmeg. And I was there.
Oh, no. Well, nutmeg's a football term as well, isn't it? When you stick the ball through someone's legs. Call it a nutmeg. No idea why. There we go.
I don't know whether you've ever Googled the chemical properties of nutmeg, but it's worth Googling.
I do nothing else, Colin.
Well, you're going to make that comment about I never get out. Meanwhile, back in the Road Traffic Act, we've got Section 4, dealt with that, very sensible. Section 5, alcohol, dealt with that, very sensible. 5A, I have doubts about 5A. Dealing with 5A for a moment in relation to the defence. There's a medical defence in 5A. And the medical defence, of course, in 5A is that you were taking these drugs, lawfully prescribed or supplied to you in accordance with the advice that you were given at the time and in accordance with the literature that was contained in the packet or even on the front of the packet. The law almost accepting that if the drugs are lawfully prescribed or supplied and you're taking them in accordance with how they've been prescribed or supplied, well, you ought not to fall foul of the law if you just happen to be over the limits. And I suspect I'm probably right in saying that most doctors are going to say to you, aren't they, don't don't operate heavy machinery, don't deliver legal podcasts, don't drive, whilst you're taking whatever drug I'm about to give you.
Yeah. So good luck getting the evidence to support that defence, Colin?
And it's very interesting. I mean, you've probably not been reading it recently, Clive, but you really ought to have a glance at section 5A, subsection 3 and 4 and 5, setting out the terms of that particular defence, because it's couched in words very favourable to a defendant. You and I both know that most of the time, if you're arguing some sort of statutory defence, you do bear the burden, don't you? It's a legal persuasive burden. You've got to satisfy the court of your defence, albeit on a balance of probabilities. Not so with the medical defence contained within section 5A, which merely requires the defendant, would you believe, to raise the issue evidentially. And the section goes on to say that if the defendant raises the issue evidentially, the court must assume that the defence is made out unless the prosecution can prove the contrary. Wow. That's very unusual. The court must assume the defence is made out unless the prosecution can prove the contrary.
So it's an evidential burden then?
It's an evidential. You could describe it as an evidential burden rather than a legal stroke persuasive burden. It's of a much lower order than a legal stroke persuasive burden.
And as I sometimes refer to it, it's more like doing the hurdles and doing the high jump.
Yeah. And I just wondered to what extent, to what sort of evidence needs to be called. Would you actually need some sort of medical evidence? Or would you just need to say, well, I was taking this, there was nothing on the literature, and the doctor said nothing to me, and if the doctor had said something to me, the legal advisor has told me I can't say it anyway because it's hearsay.
Well, not only that, but it's patient-doctor confidentiality. So
yeah, quite.
If in those circumstances, if as the district judge or the prosecutor, I say, well, can I see the literature, please? At the very least, you want to read that.
Yes, absolutely. So there we are. That's the medical defence tucked away in section 5A3. All of these sections, of course, you've got a link to all of these sections. They're sections 4 through to 7A. We've done 4, we've done 5. Let's go to section 6. Section 6 is very wordy, section 6, in relation to alcohol and drugs. It's all those things that the officer can do with you at the side of the road to determine whether or not there's something wrong with you apropos alcohol or drugs. Have you ever been stopped and breathalyzed, Clive?
No, I haven't actually. No.
Oh, a sheltered life you've led. Twice it's happened to me. Yes. And each time they gave me the little plastic thing, the tube thing as a memento of their visit. Yeah.
You got them framed on your wall somewhere?
Oh, I don't know. They're in an in-tray somewhere in my study.
An in-tray? From how many years ago?
Happy days. Happy days.
Dealing
with the Manchester police. Oof. Needless to say, I was negative on both occasions.
I wasn't going to even ask that question, whether you were negative or not. I was going to assume in your favour.
Indeed. Absolutely right. I should hope I am negative. We don't get involved in drugs and alcohol and drive.
Greater Manchester Police have got a marker in your car, haven't they? G&P have a marker on Colin Beaumont's car. There he is. Get him, boys.
I can't talk about my MI5 file on this podcast, Clive.
I can neither confirm nor deny your file.
Back at the Road Traffic Act Section 6, we've got, of course, the alcohol blow into this test. We've also got the drugs test, haven't we? And I'm told there are different tests depending on which area you're in. Some of them are sort of sweat test of the sweat on your forehead, which would be sweating presumably if you know you've been taking drugs. And the other ones, of course, are a bit of a mouth swab, aren't they? As you mentioned earlier.
Yeah, they want some fluid from you, don't they?
And if you fall foul of either of those, of course, or fail or refuse any of these tests, that gives the officer grounds to arrest. But you might be successful, Clive. Think on this. You might be successful. You might not have been drinking alcohol. You might have been taking drugs which don't show up on the little kit that the officers have in their cars. So what else? What else is there that helps the officer in Section 6, test-wise?
You can do an impairment test, can't you?
Yeah, absolutely right. Yeah, preliminary impairment tests. Yes.
Get you to walk along in a straight line, touch your nose, all that kind of stuff, isn't it?
Right, absolutely. And it may be you've passed both the alcohol and the drugs test, but the officer still has reasonable grounds to believe that you are in some way affected by drugs. We've ruled out alcohol, haven't we? So you're going to be arrested, aren't you? Back to the police station where they'll be wanting something a little stronger from you. If it's drugs, obviously, they'll be wanting a sample of your blood, will they not? Yeah. And there might be a genuine medical reason put forward as to why you can't provide a sample of your blood.
You might say, I've got a needle phobia, Colin.
You might. Do
you have to go any further than that, Colin?
I think you probably would you? Certainly if you were giving evidence in the magistrate's court, you'd have to say, look, I've got someone here to back up my somewhat flimsy tale. Please don't look too heavily at the tattoos.
Yeah, quite, yeah. Don't ask me how many COVID jabs I've had.
To back up my rather flimsy assertion that I'm a needle phobic. Yeah.
Well, this is the case of Cuns, wasn't it? CUNS, Cuns against Hammersmith Magistrates Court. Yeah. They said you can't simply say I've got a phobia and then leave it at that and then, put the ball in a prosecution's court for them to disprove you have this phobia. To simply state you have a phobia is not evidence of the phobia itself, is it? So, but as you say, the classic prosecutor's question, how many tattoos have you got then about this needle phobia? So the modern day question, I think, has got to be, how many COVID jabs have you had then?
Yeah. I'm told that with tattoos, it's a different type of needle. Believe that if you will. I don't know. I speak as a man who's never had a tattoo.
You said you were getting legal tattooed on your bicep, Colin, after this podcast.
On my what?
On your bicep.
Oh, right.
Once the bicep, says Colin.
Here we go. So, of course, if you fail or refuse to take one of those tests set out in Section 6, off to the police station you will go. If you do have a genuine phobia about needles, I don't know, but if I were the officer of the case, I think I'd want to put you in the direction of perhaps a healthcare professional. Does this person truly have some sort of phobia, or are they just trying to wind me up?
Could they take urine instead?
Well, I suppose they could, in the sense of the legislation is framed as blood or urine, but I must confess, I've never seen a report and giving figures in urine. And I can tell you, in terms of the levels on that schedule in the statutory instrument, they're all expressed in terms of micrograms per litre of blood. So if there was an expert involved, he or she would have to do the conversion, would they not? And say this amount in urine equals this amount in blood.
I think there was a case some years ago, wasn't there, Colin, in a drink drive where a Rastafarian said he didn't want to give blood. Not because he had a needle phobia, but because his body was sacred and that I shouldn't therefore take blood. I think in those circumstances, the divisional court said, well, they should have offered him urine in those circumstances instead, bearing in mind his religious beliefs.
They did hold it to be a reasonable excuse, didn't they? Yeah. And I suppose if they're after alcohol at the police station, their first port of call under Section 7 of the Road Traffic Act, of course, is to ask for 2 specimens of breath. And it's only if for one reason or another you can't provide those 2 specimens of breath that the police are allowed to resort to a request for blood or urine. And it seems to me it was always a request for blood if the person had, chronic emphysema or something like that, whereby they genuinely couldn't provide 2 specimens of breath. And the law is so framed whereby you don't have much to gain, do you, by failing to provide without a reasonable excuse, because it's the same penalties for failing to provide as it is for providing over the limit.
Well, you say the same penalties, but am I right in thinking, Colin, that the disqualification, the starting point for drink drive is 12 months, but on a failure to provide, it's an 18-month disqualification as a starting point?
Well, there you are. I'd need to check the current magistrates' court sentencing guidelines, but if that's in the current guidelines, then yes, there'd only then, if you think about it logically, be an incentive not to provide if you were going to provide and be really, really, really well over the limit. Because there are certainly guidelines as to the length of the ban dependent upon your reading.
Quite. So actually you'd be incentivized to failure to provide and then get a low disqualification.
I remember representing a guy once at Slough Magistrates Court. It was a failing to provide. The magistrate said, the chairman said, it's the worst case of failing to provide I've ever come across. And that was because when the car was stopped, he was asked to get out of the car. He opened the car door and he literally fell onto the pavement. 4 officers had to pick him up and put him in the back of their car. They had to physically carry him into the station and carry him into the breathalyzer room.
Wasn't there a case not so long ago where his defence to failing to provide was, I was so drunk that I couldn't provide?
Yes, that's right. That was Camp. That was was Lincoln Magistrates Court, where the district judge held that it was a reasonable excuse to be so drunk that you couldn't provide. And the High Court said, no, we're not going down that route. We've had to think about this, and we're not going down that route.
Oh, brilliant. I love that case.
Don't take your eyes off the ball. The mischief of the legislation is designed to protect the public from those who drink and drive.
To stop this kind of behaviour, not to encourage it.
Meanwhile, back at my man at Slough Magistrates Court, he didn't provide. He was truculent and he didn't provide. And obviously I was arguing that you couldn't really disqualify him for an inordinate length of time, bearing in mind we would never know the reading. The chairman said, I think we'll infer the reading, Mr. Beaumont, if it's all the same with you. And they banned him. They banned him for 3 years.
Quite right.
They banned him for 3 years. Oh, dear. His chairman said it was the worst one he'd ever come across.
Well, Colin, at least next time you appeared in front of him, he couldn't say this is the worst case. No, it isn't. Don't you remember that other one I did in front of you?
Right. Absolutely.
You'd set a high benchmark, hadn't you, for your next one?
Oh, the things we have to go through as advocates, eh? Dear, oh dear. There were courts I loved appearing in front of and courts I didn't like appearing in front of. And one of my favourite courts was Uxbridge, where, bless him, the chairman one day, in quite a complex legal argument, said, yes, Mr. Beaumont, looking at the prosecutor. He said, yes, Mr. Beaumont, we'll take that from you. And then he turned to the prosecutor and said, he used to be our legal advisor, you know.
Still is, apparently. Boy, prosecutor, eh?
Indeed, the prosecutor looked daggers at me.
Not surprised.
He said to me afterwards, Colin, he said, I thought this was a level playing field. No, not in Uxbridge.
Anywhere else it might be.
I used to be their legal advisor, you know. Anyway, meanwhile, back at the Road Traffic Act, we've done 4, we've done 5, we've done 6, we've done 7. We've only got 7A left. 7A tacked onto Section 7. 7A, if all the boxes are ticked, gives the police officer the power to ask a healthcare professional to stick a needle into someone and to take a sample of blood from them because they're unconscious and time is of the essence.
Yeah.
7A.
Yep.
You can imagine the scenario. Might be a bad road traffic accident. We need blood from these drivers and we need it now.
Yeah.
Yeah.
They're in a coma.
And of course, quite. Yeah. And when you are in a position to give your consent, you need to give your consent for the sample to be analysed. Would you believe? And if you don't, it's a crime not to give it.
Yeah.
Your consent, I mean.
So yeah, you give your consent retrospectively, don't you? It's an interesting.
You have to. And finally, we haven't considered it, but it's this of causing death by careless driving when over the influence with drink or drugs. That's a very wordy section. because it has to include, of course, and capture those people who failed to provide a sample, or those people who, a sample having been taken, they failed to give their consent for the sample to be analysed. And the law says, and quite rightly so, if you don't provide, or you provide, and you won't give your consent for it to be analysed, it shall be conclusively assumed that you were over the limits. Otherwise, you'd be able to frustrate that prosecution of causing death whilst under the influence of causing death by careless driving when under the influence of drink or drugs.
Few important Supreme Court cases on causing death whilst driving, isn't there, Colin? The case of Hughes and the case of Taylor as well, isn't there? And I mention them because one, they're important, and two, we don't often get Supreme Court decisions in criminal law anymore. It's like we're the lesser cousins, isn't it? It's we had one recently, very recently. I think it's the first. I can't remember the last time we had an important and decent decision from the Supreme Court about a point of substance in criminal law. Jogi, of course, but that's a few years ago now. So, but yeah, they're few and far between Supreme Court decisions in criminal law. So when we do get them, they're well worth the read.
They're well worth the read if you've got a week to spare.
Well, they're not as bad as they used to be, Colin. Not when we were at university reading decisions from the House of Lords where every judge gave a decision and for different reasons came to the same conclusion. At least half the time these days they say, we agree, we come to the same decision and we agree with all our friends on this. The prorogation of Parliament case being the obvious example. But why do I need to read 5 judgments all come to the same conclusion? Could you all just agree about some things? Because this is making my exam really, really difficult. So there we are. Not as bad as they used to be, but yes, there we are, Colin. I like a Supreme Court decision every now and then.
Well, there we are. Clive, it's been a pleasure as always. I think we've come to the end, really. I hope people are better informed in relation to alcohol and drugs, because although we've said a few things that were not entirely serious, there's been some serious discussion in relation to sections 4 through to 7A.
Yeah.
Until the next time, Clive, I can hardly wait. I know they can't. Ciao.
Thanks, Colin. Bye.
Stay off the drugs. Well, thank you for tuning in to this particular edition of the Legal Eagle podcast. We do hope that you've enjoyed it. You can find further episodes on our website, legal-eagle-training.com. On behalf of myself and Clive, thank you. Say goodbye, Clive.
Goodbye, Clive.